Breaking good news, friends. Yesterday, the Attorney General has issued a new decision in the matter of Coronado Acevedo. This new ruling has overturned the matter of SOG and FBD. In this video, I am going to talk about removal proceedings and termination of cases in removal proceedings. My name is Bijoux Ngwanda. I'm an immigration lawyer based here in DC. I work with individuals across the country and around the world because we're dealing with U.S. complex immigration law cases. If you're new to my channel, again, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing. And please do not forget to hit the notification bell so you don't miss anything. If you enjoy the content, you go ahead and share, like, and don't forget to comment below. Also follow me on Instagram. Why? Because we're talking about employment-based immigration, the business side of immigration. We're talking about investment. We are talking about self-petitions and more. You can also join me on Facebook, private Facebook group, where at least we try to answer questions live twice a month. If you need a consultation, to 751-2180, almost forget that. Bijoux.ngwandaesq@gmail.com. Consultation fees apply as usual. Let's get right into the subject. This is a very great news. As a matter of fact, this is very good because certain circuit here in Baltimore, in the 4th Circuit, we don't really have that much problem when it comes to asking a judge to terminate removal proceedings because the respondent has a way to adjust status with USCIS. As a matter of fact, we've done it with previous cases. To be honest, I've never had a problem when I have a client in removal proceedings and they're ready to adjust status, or they have become eligible to adjust status while their case was still pending with the court, of course. We just go straight to the judge and file the motion to terminate proceedings, and quite frankly, they just grant it, provided that there's no other underlying circumstances preventing it, right? So yes, we don't have really that much problem here in 4th Circuit Court, right? But certain circuit courts, for example, Ohio and the 6th Circuit Court, trust me, they have serious issue with terminating removal proceedings when the case is still pending because of this matter of SOG FDB, because that case stated that the Attorney General in that case held that immigration judges have no inherent authority to terminate or dismiss removal proceedings. So pretty much the power of termination of removal proceedings, it was out of their hands. The judges couldn't do it. They didn't really just have that power. Like that power was not given to them, right? And that was a Trump era policy. Really, that matter of SOG FDB was like, you go and try to terminate removal proceedings, then the judge will just cite this matter, and they couldn't do anything. You just have to go and adjust status in court, and you know when you adjust status in court, the standard is very high. But now, with this new ruling of Coronado Acevedo, this is a game changer. A game changer, friends. This ruling is giving judges, okay, the authority under certain circumstances to terminate removal proceedings when the person, the respondent, is eligible to adjust status with USCIS. You can file a motion to terminate proceedings in court and adjust status with USCIS, provided that you are eligible to adjust status with USCIS because of Coronado Acevedo. Wow, this is really good, and this is a great news. What happened was, let me tell you what happened in this case of Coronado Acevedo. This woman from Mexico was charged with removability, right? And then she was in removal proceedings. Then she got married. her husband filed I-130 petition, like the adjustment status petition with USCIS. Then the attorney in immigration court tried to continue the case because USCIS had jurisdiction of I-130, right? Tried to continue the case based on while we're trying to wait if USCIS is gonna grant this adjustment of status or this I-130 before we go to court. Then the judge in this court proceedings denied that continuance, okay? And furthermore, the judge denied cancellation of removal because this lady had cancellation of removal as her defense. So they denied pretty much everything that the her lawyer asked as a relief. They deny everything. Then they appeal, right? The lawyer appealed. And while the case was pending on appeal, the I-130 got really actually approved, right? And then so the lawyer got together with DHS, jointly moved the Board of Appeal, BIA, Board of Immigration Appeal, to actually terminate proceedings because now the person in question can adjust status before USCIS. Guess what? BIA refused to terminate proceedings because of this matter of SOG FDB, talking about we do not have power to dismiss or terminate removal proceedings. And this person did not end there. They went to federal, and finally the Attorney General has overruled that decision, that previous decision. And now with this matter of Coronado Acevedo, yes, you can move immigration court to terminate removal proceedings while your case is pending with USCIS based on adjustment of status, provided that you are actually eligible to adjust status. This is really great news, okay? This is really great news. If you are in removal proceeding, meaning that the case is still open with immigration court and you are eligible to adjust status with USCIS, whether I-130 is just pending or whether you really is approved and you want to go further to adjust status and USCIS does not have jurisdiction, my friend, you should use this case and try to terminate removal proceedings and just move with USCIS to adjust your case. This is a great news for this morning, and this actually is good for this time being. You should use it because we never know, right? If Trump is gonna come back, then they're gonna have another attorney general who might, we don't know, who might just go back and revert back to the matter of SOG FDB. My friend, just take advantage of it now when it's still the law now, okay? So that was it for today. 202-751-2180. Email Bijoux.Ngwanda.esq. Consultation fees apply as usual. Until next time, bye-bye.